Nicola, following the Supreme Court's decision in BPE Hughes Holland, what do you think still remains unresolved in applying SAAMCO to lender claims against solicitors?
Well, William, first of all, what's clear, it has made it clear that you must apply the two-stage analytical test. That is, first of all, what, if any, loss would have been suffered if the solicitor had not been negligent, i.e. factual causation. And then secondly, a different hypothetical, would the same or would a lesser loss have been suffered if the situation had been as the solicitor represented it, which is the scope of duty or SAAMCO test. It also confirmed, BPE, that so far as the burden of pleading and proving these both scenarios are concerned, this is on the claimant. And it confirmed that if the same loss would have been suffered in our second hypothetical, that none is recoverable. And finally, it confirmed that if the misinformation went to the value of the property, it's treated like a valuer's negligence case, i.e. you look at the difference between the apparent value and the true value at the date of the transaction. What is unresolved, however, though, is how you deal with those cases where the misinformation went to the solvency or the honesty of the borrower, i.e. to what you might term the value of the borrower's covenant and the likelihood that the payments would have been met. And we're clearly going to need some further clarification from the courts on this, because Lord Sumption and BP overruled previous decisions of lower courts on this issue, but didn't give any specific guidance as to how either those or similar cases should have been decided.
So how do you think the courts will approach that question?
Well, first, and importantly, it needs to have been clear that the solicitor did have an obligation to provide that information to the lender. With information relating to the borrower covenant, frequently this information will not have been the solicitor's responsibility to disclose, and it may very well be information which was equally or better available to the lender than the solicitor. Consistent with BPE, it's likely that lenders will have to call evidence to establish that their losses would have been less if the situation with the borrower had been in accordance with the information provided by the solicitor if information was provided. Now, it has been said that in NICredit some time ago that valuing a borrower's covenant would be a relatively easy matter, but in fact that hasn't proved to be the case at all. It's not a straightforward thing to do. A lender will need accountancy evidence, it seems to me, in order to prove the value of a borrower's covenant, both as to its apparent and its true values at the date of the transaction. Now, in the great majority of cases, particularly if we're looking at prime lending, a lender would expect the mortgage to be discharged by the borrower payments rather than by having to resort to the security at all. And it can be expected, therefore, that lenders will call evidence as to the very high proportion of their loan books which had historically held good. And it seems to me that the lender arguments in such cases will be that the payments would have been met and that no loss would have been suffered, and so that all of the actual loss is within the scope of the duty of care, so far as the second SAAMCO hypothetical is concerned. Therefore, it seems that the easiest cases for lenders will be the most extreme ones, the ones where the borrower made no payments, was probably a fraudster, and where the correct information would have revealed that they were a fraudster or that they were insolvent. However, because much of the information about borrower solvency or honesty would also have been available to the lender, it seems to me what we can really expect is that the real focus will be on whether there was any duty to disclose the information at all on the part of the solicitor. And then also causation questions as to whether it would have actually made any difference to what the lender would have done in terms of their internal procedures. And then also seeking big reductions for contributing negligence because of the obligations that were on the lender, even if there was also an obligation on the solicitor.